Hey everybody, it's attorney Veronica McClendon, and I have a favor to ask of those of you who are bringing your loved ones to my law firm for estate planning. Now, what I'm about to say, I'm hoping that it does not bother any of you, but I want to ask that you please do not take offense when I ask you to leave the room. So, like I said, this is for those of you who are bringing loved ones to our law firm. It might be a parent, a brother, a sister, even a child, a niece, or a nephew. You might think, okay, I'm going to help this person through this process. I love them. I want to make sure they feel comfortable. So, I'm going to be with them every step of the way. There may come a time when you come to work with my firm, particularly on the first meeting, possibly even on the second meeting, where I will ask that you, if you are not going to be the client, that you please leave the room. And there are a lot of reasons for that that I'm going to talk to you about during this video. But I just wanted to give that preface that a lot of times when you are going to work with an estate planning attorney, you might think that this is a family process, this is something I should be involved in, but it's not unusual for the lawyer who is working with you to want to have some one on one time with the client. And I know that sometimes you might think, well, they need some help. They're not able to do this kind of a business meeting by themselves. There might be some things that I need to explain to the lawyer, and so I want to be there so I can do that for them. And I do understand all of that, and all of that may be needed at some point during the conversation. But there are a lot of things that attorneys are doing during the estate planning process that are outside of trying to get the information needed to do the estate plan. A lot of times people think that they're helping their loved one, they think they're helping the attorney, but they're actually hindering the process. So some of the things that we are trying to do when we're in the estate planning process, the first thing is assess the client's capacity. So if someone is sitting in front of me and saying that they want to create a will or create a trust, as the attorney, it's my job to make sure that they have the right mental capacity to take that task on. If they don't have the right mental capacity, then I probably won't be able to do a will for them or do a trust for them. I might need to talk with you about some other options that are available. But it's very important for me as the attorney very early on to make sure that the person that I'm potentially working with as a client has the mental capacity to take on that role. So I'm going to want to spend some time with them, getting to know them, build rapport with them, make sure they feel comfortable with me, make sure I feel comfortable with them and that I can understand where they're coming from. I'm going to ask questions about their family, their property, what their goals are. And those are things that I want to hear just from the client because it's going to help me to make sure that they fully understand what's going on in the process and also make sure that I'm getting very clear on their wishes for the estate planning process. A lot of times, well-meaning family members may want to provide input because they might think, well, my mom or my dad doesn't really know what's going on. They don't really know what's best. They're not real good with handling business. So I need to put my insight in there to help them create a plan that's going to be best for them. I want to say first that as an attorney, that's part of my job. A lot of times people might think that the attorney is there as like an outsider who is not as concerned about the client's wishes and what's best for the family. But I will say that for me, and I think most estate planning attorneys, we are there to help support the client where they are. And we don't need to have them be at this certain level in order for us to work with them because we're there to accommodate for them wherever they are, whatever needs they may have. So, as I mentioned before, one of the first things that I am going to be doing when I'm meeting with the client is finding out what their capacity is to participate in the estate planning process. Like I said, also want to make sure I'm building rapport with them, getting them comfortable working with me, talking with me, sharing with me. And if it's not possible for that to happen, if they don't feel comfortable working with me, then it's important that we figure that out early on. And so that's why I would like to have that one-on-one time with the client to just make sure it's going to be a good fit for both of us. Another thing that we are doing when we are working with clients, particularly in that first one or two meetings, is making sure that there is no undue influence. Now, you as the loved one who's bringing them there, you're probably not going to be there with any malintent, any negative goals for the person that you brought with you. But sometimes people are. There are situations where perhaps there was a child who fell out of favor with the parent over the years, but now that the parent is getting older, a little weaker, may not be as sharp as they were before, or might be a little bit more emotionally vulnerable. This child comes back out of the woodworks and is now mom's best child, favorite child, daddy's favorite child, and they might have goals for the parent's estate planning that are contrary to what the parent would have had if they weren't there. And it's not always a malicious thing. Sometimes just having somebody else in the room, particularly someone that you either want to not upset or someone that you want to please, you might say things a little differently than you would if they were not in the room. And so, as an attorney, it's very important for me to be on guard for any potential undue influence and make sure that the client is telling me exactly what they want to have done for their estate plan and not what somebody else thinks is best for them or what somebody else thinks that they should do. And I want to also point out that when it comes to doing estate planning, particularly when you're doing a will for someone, the level of mental capacity that's required is very low. So, someone who may not be able to handle their own business on the marketplace, like they may not be able to sign contracts, they may not be able to sign deeds to real property, they might still have the amount of capacity needed to execute a will. And my job as the attorney is to gauge that. I will say I just spent the past several weeks researching a paper on who is the client and understanding client capacity to be a client and client capacity to do estate planning and all of those things. I just spent several weeks researching that. And so I kind of have a unique and I guess detailed perspective on how to make those assessments and how important it is. That's why it's so urgent to me now. It's so important for us as attorneys to take that time out with the client without having other people in the room. There's one more thing that is very, very critical. That has nothing to do with undue influence, has nothing to do with client incapacity, and that is the attorney-client privilege. When a lawyer and their client are in the room together sharing information, then that information becomes protected by the attorney-client privilege. That means that if for some reason one of the parties in the process were brought to court and forced to testify in court about the transaction, perhaps they want to know about the estate planning process, make sure everything was done right. If stuff like that were to happen, then the attorney can say anything that I talked with my client about is going to be protected from being revealed in this process. And bringing a third party in, someone who's not the client, ruins that attorney-client privilege. And so the attorney-client privilege is very important between a client and their attorney to make sure the client feels comfortable sharing what they need to know without fear that it's going to be brought out in court and made public for the world to know at some later date. They might have some secret information that they don't want to be public. They might not be trying to hide anything from their family members, but they wouldn't want it to be a public information. And so when that communication is made to the lawyer, to the attorney without other people present, then that attorney cannot share that information in court, and it's not otherwise going to be what's called discoverable in court. So that's another thing that attorneys may be thinking about when they ask you to leave the room when they're talking with the client concerning estate planning. They don't mean any harm. We don't mean any harm. We're not trying to offend anybody. We're not trying to make anybody upset. We're not trying to keep anybody out of the process, but we're just trying to guard this attorney-client relationship. Estate planning is becoming more and more litigious. There are more family members who are getting resources to be able to fight things out in court. And so these things that I just talked about become even more important in that kind of situation. So if you are bringing your loved one to an attorney to work with them on estate planning and they ask you to leave the room, please don't be offended. They're doing that for the best interest of the client. They're doing it to protect themselves as the attorney. And they also might be doing it for you because you, as a future potential beneficiary, would not want what you're receiving to be disrupted by someone accusing you of providing undue influence on the client or wrongfully inserting yourself in the process. You don't want to put your inheritance at risk or your ability to serve as your loved one's fiduciary, their power of attorney, their executor, their trustee. You don't want that to be put at risk because you were participating in the process in a way that someone else might consider to be a wrongful participation, or you exercising some undue influence on the person doing estate planning. So all those things, just making sure I got all my little things that, with attorneys, we're looking at things like assessing the potential client's capacity to create an estate plan, building rapport and trust with our potential client, understanding the client's true wishes and making sure that nobody else's influence is influencing, is affecting how the client is making decisions for their estate planning. And then we're also looking at protecting the attorney-client privilege. So I just wanted to share this. Like I said, I've been researching this paper for a while, and so it's top of mind. And I wanted to share these insights that I've gained and make sure that everybody who is participating in the estate planning process, whether it's the lawyer, the client, or loved ones who are supporting the client through the process, just wanted to increase transparency so we know what's going on and we can be fully informed about how estate planning works. If my firm could be of any assistance to you or a loved one, please do not hesitate to find our contact information in the description below and let us know if we can help. Would love if you would subscribe to this YouTube channel, like this video, share it with a friend. Y'all take care.